Welcome to the WN Legal Podcast.
Welcome to another of WN Legal's podcast. My name is Q. Before I proceed further, I just want to canvass another disclaimer. I do it every single time. Is that this podcast is not meant to be legal advice for your specific circumstances. It's only a podcast to assist the public in understanding law and the areas of law. Today, the podcast will be on cross-examination and trials, specifically what happens at trials for self-represented litigants and what do they need to know. Trials, before I proceed any further, I just want to make a comment that trials are very, very interesting. I can never get bored of it because any facts that you put into the mix for a trial would come out to a different outcome. Different magistrates, different judges, different set of juries, a panel of juries would all come to a different decision. There are sayings where you get 10 different lawyers, you get 10 different outcomes. That's probably why, and I'm going to explain to you why today, and perhaps get rid of that stigma that all lawyers are producing different things. Today I'm going to be talking about the mechanism of trials and how it became what it became. And that's the reason why in Australia it's a very adversarial process. It's not inquisitorial, it's adversarial. Both parties can then present their facts, and then with what I will be explaining later, then you'll know why it is what it is. The trial side of things that I'm going to be explaining today is specifically on criminal as well. As we know, the prosecution needs to prove beyond reasonable doubt. The prosecution needs to first establish the facts of the case, and they're going to call their witnesses. In a very contextualized setting, I'm just going to explain to you what happens when you go to court. First thing you do is you stand at the bar table, you address yourself, and then the prosecutor is going to address yourself. In the last podcast, I did mention everything up until trial, but in a very, very brief manner. It's not specific enough. But after all those procedures, when you go to trial, you would already have the statements, the evidence against you, and what they wish to say. But do not rely on it with everything, because when a witness goes up to the stand, you don't expect them to remember every single thing they write, and that's the beauty of trials, because that can amount to prior inconsistent statement. I did write a quick blog about prior inconsistent statement on WN Legal website. I do urge that you go on it and check it out, because that will be the bread and butter for most trials. So the prosecution first gives opening submissions. The defense can choose whether they wish to or wish not to give an opening. And for the defense, in a criminal matter, in the Criminal Procedure Act says that you can either do your opening right after the prosecutor has done their opening, or after the prosecutor closes your case. So perhaps if you have a pen and paper, that would be very handy for you to note the stages of trial. First of all, the prosecutor does the opening, and secondly, the defense then decides and elects whether to do opening then or in the middle of the trial. When I say in the middle is when the prosecutor has given their evidence. The prosecutor or the prosecution would then call their first and principal witness, secondary witness, any expert that they have, and that's usually the order of how they're going to give. Those guys will go up to what we call a witness box. When they're in the witness box for each and every witness, so I'm going to break it down further, each and every witness would then need to give what we call examination in chief, and then it comes down to either the accused or the accuser's counsel to then give cross-examination or to conduct cross-examination on the specific witness. And this process will occur for every single witness unless the accused or the self-represented litigant makes a certain set of concessions, such as identity is not an issue, I did punch him, so I'm not disagreeing I didn't punch him, and if you're going to make these kind of concessions, the statement can be read. They don't need to give evidence, so to say. So the prosecution's case usually involves calling all of their witnesses. And when I say they close their case, that's not the end of the trial. That's usually just about the middle. Because when they close their case, all of their witnesses would have given all of the evidence. And then the defense or the accused or the self-represented litigant would then have to decide whether or not, number one, the prosecution has proven beyond reasonable doubt. If they have not, and I repeat, if they have not, you need to make submissions to the court and tell them, look, they haven't proven beyond reasonable doubt. It's not me. The punch didn't make contact. There's a video of it. It didn't make contact. I didn't breach this restraining order. I wasn't here. I was somewhere else. Alibi evidence in the Criminal Procedure Act. You'd completely dispute the facts. But if you completely dispute the facts, you can't just close the case. Because if the prosecution has laid out the case in the factual matrix well enough, you then need to rebut it. How are you going to do so? In the middle, when the prosecution closes the case, you would have already done a few cross-examinations on each and every one of these witnesses. And the cross-examination of each and every one of these witnesses would then dictate whether or not you have managed to disprove a certain set of facts. If you think you did and you choose not to give evidence, then go ahead and close your case. But again, this is not an advice because I personally wouldn't do that unless I'm absolutely sure that my cross-examination has covered every single facet of the defense. When I mean absolutely sure, out of 10 trials, perhaps only 1 or 2 of them would manage to close at this stage without any fuss and without the accused giving evidence. Because if the witness is a police officer, you can expect a verbatim approach in the evidence giving in the statements. But if it's an independent witness, depending on the capacity and the intelligence and the ability to withstand cross-examination, you may have a very difficult time. After the prosecution closes the case, this is when the defense can either choose to give evidence, to do their opening here, and it's a very tactical approach. If you don't do it in the beginning and you do it halfway in the middle, you won't need to eat back on your own words. Because, for example, the prosecution says, oh, this man was here in this pub. And you start your opening right after that. No, I wasn't there. No, I wasn't there at all. I was in McDonald's. And then you have all the prosecution witnesses go, he wasn't in McDonald's. He was here. He walked past here. He walked past here. And the CCTV is here. I've shown you the CCTV. And if you do your opening in the beginning in those set of circumstances, you're just going to have a really tough time. You're not going to like the trial because you're probably not going to win. So sometimes opening in the middle is a very, very tactical move, and it can be very advantageous because the police would have to show their hands, the prosecution would have to show their hands, show everything that they have. All right, here's the facts. You were here on this day, you were here on this day, this is what was happening, and this was the act, and that's why you're guilty. And then you go and you open in the middle of the trial, you go, well, wait a minute. On this day, you say I was here, but where's the proof? And you say I was there in McDonald's, where's the purchase transaction? And things like that. So if you open in the middle, it can be very advantageous. In my experience, I do it 50-50. I only open in the beginning when my client comes to my office and done his proof of evidence or her proof of evidence, and I'm fully satisfied that there's no issue whatsoever, and I have the ability to do it in the opening, in the beginning, I do it. Every magistrate or every judge has a different view. So you can only, it's like reading between the lines. Some magistrates go, okay, if you've done your opening in the beginning, you must be clean. But if you do it in the middle, you're not clean. It doesn't even matter at the end of the day. That's not what matters. What actually matters is whether the prosecution can prove beyond reasonable doubt. So that's one of the main decisions you need to make, whether you want to do your opening in the beginning or in the middle, and whether or not you want to close in the right after the prosecution has finished the case and choose not to give evidence, which is exercising one of your right to remain silent during trial as well. That is a very tactical move as well, whether or not the accused should give evidence. I would recommend that you speak with myself. During the first initial consultation, a lot of people do not think much of it, but lawyers are there to then decide based on the visual cues and the conversations with the clients whether or not they can withstand cross-examination, whether they have anxiety issues, whether or not they can deal with competing set of circumstances. Would they get angry? When the magistrate looks, or the judges or the panel of juries look at a person up in the stand, what makes you think that you're going to be guilty or not guilty? They're going to look at your impression, how you stand up, how you talk, how you sit down, whether you move your hair all the time, you look up to the ceiling, whether or not your version of events is credible and reliable. So when you go through cross-examination, whether can you withstand cross-examination? If your set of facts can withstand the test of cross-examination and you're solid as a rock, perhaps you'll be fine. Perhaps. The next issue then is corroborating evidence. If you have 9 police witnesses and one of you in the room, and you say you're solid as a rock, you didn't do it, but 9 of them have said you've done it, what are you going to do? That being said, don't decide to plead guilty at first instance. I've done about maybe 20 trials in the last 5 years with the same set of scenarios, but there was one just done 2 months ago. 9 witnesses, 4 police officers, 5 independent witnesses, my client and only her immediate plus one. And in that case, when the prosecution stopped calling every other witnesses after their third witness, because in cross-examination, I've covered all these points. Well, I'm not boasting here. But what I'm trying to say is cross-examination is so important because if you cover enough points, they know calling any other witnesses is not going to be tenable to your case. It's all tactical. So apart from all these issues, next thing you need to do is cross-examination. How? How do you cross-examine? Everyone asks me, what do you do when you cross-examine? When you're up there in the stand, what's the first question you ask? How do you proceed in asking these questions? Now, the Evidence Act only covers very limited rules of what you can and can't do. The rest of them are all from experience. All from experience. Any hearsay evidence, speculation, opinion, all these evidence will be usually ruled out. But in restraining order proceedings, the new amendment post-July 2017 allows the magistrate to consider hearsay evidence in restraining order proceedings. But in criminal proceedings, the rules have not been relaxed. So if someone goes, oh, I heard my mom said that my brother was doing this, immediately ruled out. I spoke to the police officer and the police officer said to me that I'm guilty, immediately ruled out. Because those are speculation, opinion, or hearsay. One or the other. Speculation, what do I mean by that? Oh, he's got dreadlocks, he's guilty. Now, that's simply not tenable, not possible. Any kind of evidence like that will be immediately ruled out in the criminal proceedings. Opinion, oh, I know my daughter, I know her very well, she will not do this. Again, opinion, ruled out. So in cross-examination, you first decide what they've said. You must listen to them talking very carefully. The first point of contact is you hear what they have to say, make notes. Look at their statement that they've given to you. They said in the stand, oh, I did not see this person looking left. But in their statement, they go, I was sitting down there, I had a full view of the situation. Now, what's immediately presented to you is prior inconsistent statement. What she said or what he said on the stand is different from what's said in the statement. Point them out. Figure them out. But the problem is this preparation could not be done before the trial. It actually happens when the trial is going on. Don't decide to do it yourself. Get someone that has experience and has done that before and know what you're doing, okay? Speak to a lawyer. When they've done adequate preparation, prior inconsistent statement under Section 21, my apologies, I think it's 21 or 24 of the Evidence Act. I could be wrong. It may be 24, but I believe it's 21. It does say that if there's prior inconsistent statement, you actually have a certain set of rules and procedures you need to follow. So you can't just go in there, you're wrong because you said this in your statement. No, you got to ask them, did you say this in your examination in chief? Do you say that you were looking left? Yes. Did you write a statement to the police? Yes. Do you swear the statement or do you sign a statement? Yes. And you agree that what you said in there would have to be the truth? Yes. Look at the time and date of what this statement is. When was it signed? If it was signed about 2 weeks after the alleged offending, and why is it so different from your evidence today? Then you ask them, are they lying on the stand or in the statement? Then they would be stuck. Because if you ask them, are they lying on the stand on the statement? They don't want to be seen to be lying. So these are things that you would need to actually consider. There's a lot of ways in cross-examination where I wouldn't say trap. You don't trap a witness, but you find out the truth of what was being said. And that's the reason why you get 10 lawyers, you get 10 different answers. Because up in the stand is where all the magic happens. Well, magic to me. But to a lot of people, it can be quite daunting. So apart from the rules of hearsay, speculation, and opinion, I've just explained to you how prior and consistent statement works. A lot of times, it also includes memory recollection. So if you have 4 witnesses go in there and say the same thing about the same set of circumstances, I'm going to give you an instance. I'm in a room right now. I'm doing a podcast. I have here Kelly. She's together with me. She's from Visible. And just the 2 of us in the office, then 9 police officers stomp in. 9 police officers. Okay, they go, okay. Officer 1 would then go in the room, look at everything else. Officer 2 would speak to Kelly. Officer 3 would speak with myself. Officer 4 would help Officer 1 to look at everything else. Officer 5 is the exhibit officer. He's going to be keeping anything that they see in the room and then going to keep them as evidence, and the list goes on. 9 officers, they probably have 9 different versions of events. They're not all in there to do exactly the same thing, look at you and talk to you. So figure what their rules are as police officers, or as a layman, if they are a layman person, they're not officers, when they're there, what they're doing there, and what their purpose is. Because when you go and look at every one of their statement, it's either going to be exactly the same or a bit different. What's different and what's the same? Listen to them talking up in the stand. Are they different from the statement and different from each other? Because you can put them and pit them all against each other. Are you saying Officer 1 is wrong or you're wrong? Are you saying your statement's wrong? Things like that. They can affect what we call the proof of evidence, whether the prosecution can prove beyond reasonable doubt. I had a case 4 years ago. I remember very specifically. My client was said to be spitting at a police officer. There were 6 police officers at the scene. Wait, no, this one was actually 9, exactly 9. 1 officer was spat on. The rest of the 8 officers were there at the scene. It ended because of it was a high-speed car chase. And 9 officers were there. 9 different versions of events came out in court. And she was acquitted because even with 9 officers there, everyone looking at the same thing, doing the same things, all have different recollection of how it happened. You need to pinpoint what you want to do. You need to know where you want to go. Stick with the facts of the case. Don't ask anything about their parents or their grandma. Don't ask anything about their qualifications unless you know exactly what you're doing. You can't go, you're an auxiliary officer, then why are you here? You can't go, you're only a constable. Now those kind of cross-examination line will get you nowhere. In fact, will not get you anywhere whatsoever. You just need to focus on the facts. If you were there, you were the one holding my hand, grabbing my hand, holding my hand back as you arrest me. Where was your other hand? Questions like that. When you look at the facts, were you looking left? Were you looking right? If you told me that something fell in front of me, how big was it? Small, big, medium size? What color was it? Look at those things. Because I had another trial, again, an assault trial, broad daylight in the middle of the traffic light, in the middle of the street. There were 4 officers who gave evidence of what had happened there, and they were all different. Once you are done with cross-examination, if you've done it correctly, they would all be perhaps different. So that's the magic of cross-examination, and that's the reason why you have 10 lawyers and you have 10 different answers. I guess that will be the heading of the podcast: 10 different lawyers and 10 different answers, and how to do it in cross-examination. But these are cross-examinations for criminal matters. Family is completely different. Family law is completely different, and I will do that perhaps in my next podcast or one in the future. Thank you for listening, and I hope you find this interesting.